Lamarr Baxter, the Director of Business Development for AccuPlan Benefit Services. I'd like to thank everyone for joining us on today's webinar, a very sought-after topic that we'll be covering today, the use of a retirement account, in particular the 401k, to be able to fund a startup or existing business. So today's actual title of the webinar will be entitled, Exploring the Legal Use of the R.O.B.S Plan for Business Startups with the 401k Funds. Today's guest speaker will be Mr. Frank Selden, an attorney out of Washington State, who will be covering the use of the R.O.B.S plan for starting a startup business or for use of those funds for an existing business. To kind of give you an idea of what we're going to be covering today, we're going to be covering what is a R.O.B.S, what is its uses, what are the pitfalls to avoid, and the rules that must be followed in order to use this structure to use this type of fund, should I say the 401k funds, to start to fund a startup or existing business. The subject of the R.O.B.S, which is also known as rollover for business startups, which is an acronym, as I say, for R.O.B.S, is the rollover for business startup, has been a much debated subject amongst both legal and tax professionals. And now we'll be hearing from Mr. Frank Selden, who specializes in providing consultation for those investors as well as individuals who are seeking a better understanding of this investment structure that allows you to use your 401k funds via a sophisticated structure to invest in a startup business and receive compensation. Opinions about the legal validity of the R.O.B.S plans range from it's blatantly illegal, it's too complex that it needs to be avoided, it's too easy or so easy that an entrepreneur just needs to pay a particular company and sign a few forms and they're ready to go. There is no specific single rule that delineates a R.O.B.S approach and no rule that prohibits it. Rather, the strategy uses regulations from several sources which, when pieced together in a proper framework, allows the individual to invest their own retirement funds into a corporation form from the employer's properly drafted 401k plan to be able to fund both an existing as well as a startup business. A R.O.B.S strategy is a viable funding strategy if the entrepreneur follows all the legal requirements in accordance to IRS codes for establishing and operating the 401k plans and offering qualified employer securities to employees. So this is something that's also, if you're setting this up, you're going to make sure that this is also offered to the employees. Okay, a properly structured and administrated R.O.B.S arrangement can satisfy both the requirements and the spirit of the all tax laws and serve as legitimate tax and business estate planning purposes as well. This seminar helps entrepreneurs understand the possible legal pitfalls and take seriously their ongoing responsibility as fiduciaries of their company's retirement plans when funding their business through a R.O.B.S arrangement. Just to give you an idea, or should I say just cover Mr. Selden's background, Frank focuses his practice on rollover business startups, so this is not just something that he's starting to do. He's been doing this for many years. As I mentioned, his focus is for rollover business startups, self-directed IRAs and solo Ks, and estate planning for business owners. Prior to entering the field of law, he basically was in the industry of banking and insurance. He's also a judge advocate in the Washington Army National Guard. He served two tours in Iraq. While say he's an expert in self-directed retirement planning, Frank prefers to basically be considered his experiences in active listening and creative thinking. So this is something definitely that, once again, is not for everyone. And I'm sure Frank will basically cover, for those who are just looking to use funds to receive compensation from the 401k. This is not the active vehicle to be using that for. You're better off more likely taking a distribution. This is really a structure to where if you're going to be using your 401ks to actually fund an active and viable business, this is possibly an option for you to consider. Before we get started, just going to go over some housekeeping rules. I'm going to basically cover our disclosure because, as I mentioned in previous webinars, we're not here to basically give you advice or to steer you towards any particular investment. Our objective is really to give you education and hopefully take that education over to your financial, legal, and tax professional to assist you in making a decision as to whether a particular investment or an investment structure is right for you. So with that being said, be sure to definitely consult with both your tax, legal, and financial professional before moving forward with any investment. And if you have any questions after this presentation, both myself as well as Frank will be available for any questions you may have relative to the content that will be covered in today's webinar. All attendees will be in listen-only mode. This webinar will be recorded, and within the next 24 to 48 hours, I'll be sending out a playback link for you to listen back at your leisure, as well as to forward along to others who were not able to log on to today's webinar. All questions will be submitted via chat feature. As I mentioned, you'll be in a listen-only mode, so any questions that you may have, feel free to type in those questions via the chat feature. And towards the end of the presentation, we'll answer as many questions as we can. Any questions that we're not able to answer, we'll be happy to answer any questions after the call. So with that being said, I'm going to go ahead and turn this over to Frank, and I'll go ahead and click this over to your PowerPoint presentation. Okay, can you see your presentation?
I'm looking at the disclaimer.
Okay, we should be ready to go.
Slide on my end still is the AccuPlan disclaimer.
Were you able to see my screen?
I can now. Yes, it just moved over. So thank you for that introduction, Lamarr. We want to click on to the next slide. What I'm looking at right now is the it's my contact info.
Okay, it sounds like there's a slight delay, so we should kind of move forward.
So the goal of a rollover business startup is essentially the creation of a C corporation that is sponsoring a 401k plan for the benefit of all of its employees. And the reason that this concept is not a prohibited transaction or allows you to use your retirement funds to invest into something where you are also materially involved is because of the 401k plan language that has an exemption to the prohibited transaction rules for something, a transaction called qualified employer securities. When an employee of a corporation invests their qualified funds into the stock of the sponsor and employer, then that transaction is exempted from the prohibited transaction rules. This is an exemption that has a lot of companies rely on this. So pretty much any company with a 401k plan, a certain kind of pension funds, or an employee of those corporations, whether it's a small brand new startup or a large company like Microsoft or General Motors, they can invest their retirement dollars into the stock of the sponsor and employer. Now this setup has some requirements that go along with it that we're going to cover in just a minute, but essentially the goal again is a C corporation. And it has to be a C-Corp sponsoring a 401k plan for the benefit of all of its employees, and then the funds being transferred into that 401k plan and then invested into the company. Go ahead. So the requirements, essentially, again, starting off with, we have to have a C corporation. This exemption is not allowed for an LLC, limited liability partnerships, S corporation, etc. The client needs to realize, or the entrepreneur needs to realize, that this plan is for the benefit of all the employees of the company and any control group companies. So if they own any other businesses and more than 80% or more overlap in ownership, then all of those companies, the employees of this particular company, will have access to the 401k plan or have rights under the plan. Another piece to keep in mind is that the plan and the corporation have federal and perhaps state filing requirements that would need to be adhered to. Some of these are a little more complicated than would be required, for example, by a sole proprietorship. So we have to keep those in mind and make sure that we are staying current or on top of all of those filing requirements. Another requirement is that the client must be an employee of the corporation. So we don't do a leaseback arrangement, but they have to be an employee of the corporation, and that creates rights for them under the 401k plan that allows all this to happen. And the last point on this particular slide is that the corporation must have at least one other shareholder other than the plan. So the plan should not own 100% of the stock of the company. Somebody other than the plan, it's usually the entrepreneur that's going through this process, needs to own at least a non-de minimis level of stock in the company. 2 to 3% minimum has to come from their own funds. So the client ends up playing a lot of roles in this scenario. They're a shareholder of the company. They're on the board of directors. typically an officer of the company, like president, secretary, treasurer. They're also an employee of the company. They're the plan trustee, plan administrator, and plan participant. And each of these roles can have federal and or state rights and responsibilities that go along with them, and it's the client's job to make sure that they're following all of the different rules for each of these roles. And sometimes these roles come into a conflict of interest. Usually not, but for example, as a plan trustee, they have a fiduciary responsibility to ensure that the investments inside the plan meet a reasonable, prudent investor standard. And there are times where the corporations that sponsor these plans would not meet that criteria. And then it would be the role or responsibility of the trustee to press to have the plan no longer be a shareholder. So we help walk people through that as well, and sometimes that does happen. But these are the basic roles and responsibilities that the client is going to find himself in with this process. Go ahead. So here are the steps. Now, normally when I'm going through the steps here, the client or entrepreneur is not responsible for most of these steps. If they're hiring a R.O.B.S promoter like AccuPlan, there's being a product put together that basically includes all of this. It's just going to get handed to the client. So, but these are the steps that they're going to go through. One is the new corporation gets established. Usually the R.O.B.S promoter is going to take care of that. Sometimes the client comes in with an existing corporation, but we have to be dealing with the corporation, and that's the first step. Then the corporation is going to hire the individual as an employee of the company, and simultaneous to that, the corporation is going to sponsor or adopt a 401k plan. Now, this 401k plan has to have specific language inside of it that allows this structure to take place. Not every 401k plan out there allows for qualified employer security stock. Most 401k plans, in fact, might give you 8 to 10 of the not best performing mutual funds from the same mutual fund family, and that's your entire selection. These R.O.B.S plans usually allow for any publicly traded stock, bond, mutual fund, etc., and in addition to that, allow for company stock, at least for a period of time, but all of that has to be specifically allowed by the plan. The next step is that the client is then going to direct their current custodian to transfer or roll over their qualified funds from their current account into an account that gets set up in the name of the new plan. Go ahead. Then, as an employee of the company, you're directing the plan to invest your qualified funds into the stock of the corporation. The client, again, also simultaneously purchasing some stock themselves, sometimes as a reimbursement for expenses they've already paid out of their own pocket on behalf of getting the company going. Then the corporation has cash in the bank, and the corporation can do whatever it's going to do. The good news about rollover business startups is that the corporation is not under any different accounting rules than any other corporation. There's no limits on what the corporation can or cannot do that would not also apply to any other corporation. So any legitimate legal purpose, as long as the corporation is an operating company and is in business producing a product and service for profit, there aren't any other restrictions. So it's all standard accounting, standard generally accepted accounting principles, and including paying the client a salary for the work that they do on behalf of the corporation. Go ahead. But those are generally the steps, basically, from initiating the corporation through to the funding of the corporation, issuing stock back to the plan and shareholder. So some tips that I've seen along the way, one of which is sometimes time delays happen because the client or entrepreneur going through the process does not understand who's doing what at what point. So one of the tips is to know what your promoter is doing for you versus what you need to be doing for yourself. For example, who is the registered agent for the corporation? I've seen some people be confused about that, and they think that the promoter is doing this for them, and typically that is not the case. Typically the client is the registered agent for the corporation and may have some filing responsibilities with the state ongoing to keep the corporation in an active status with the state. Some clients also believe that promoters do handle the rollover request with the current custodian of their qualified fund. That is definitely not the case. Security companies are not going to listen to some company calling them up on the phone and say, hey, this so-and-so is our client and they want their qualified funds rolled out of that account they have with you over to this account. It's not going to happen. They need to hear from you, the individual client entrepreneur, that that's what you want. Another confusion I've seen some people have is, oh, we thought that they, the promoter, were going to issue the stock from the company. Typically not the case. Some of them might work with you on that, but usually it's up to the client as the officer of the company to actually issue the stock both to themselves and to the plan. And then also who creates or files the annual corporate and plan returns. Plans have their own set of returns that need to be filed. Somebody needs to be in charge of that. Actually, the client as the trustee, the administrator of the plan is responsible. Normally, they hire a third-party plan administrator or work with their promoter or some company in some kind of relationship to take care of that for them, but they are usually the ultimate responsible party. Go ahead. So the basic tip there again is knowing what the promoter is doing for you versus what you need to do for yourself. Now, Lamarr had correctly identified up front that this product, the rollover business startup, is not for everybody. And there are some reasons I've seen people go through a rollover business startup process that I believe personally that a distribution or something else would have been better for them. One of the reasons is they need some money. Well, take a distribution out of your plan. Take a loan from your plan. If the goal is that you need some cash right now to pay bills, creating a pseudo corporation in order to mask money coming through that into your own pocket, not a good idea. Another reason not to use a rollover business startup, some people say, well, I really want to take a distribution, but because of the 10% premature penalty and taxes, et cetera, it's cheaper to do a rollover business startup. To me, not the right answer. We'll get to the proper reasons to use a rollover business startup in a second, but just because it's cheaper than a distribution doesn't make it a good idea. The third reason not to use a rollover business startup, I've seen sometimes people will offer a 401k plan to all their friends and family. Hey, now we have a 401k plan. Everybody, throw your qualified funds in here. Can't do that. The only people who have access to this 401k plan are the actual employees of the company, and that's it. So don't just adopt a 401k plan just because you want to look good with all your family and friends and give them a spot to put your qualified funds. Last reason I recommend not to use a rollover business startup is to save an existing company. And that is because of the prudent investor standard that 401k plan trustee would be under to make sure that all of the investments meet the standard. If the company is going under and you're just throwing good money after bad, so to speak, delaying the inevitable, if this is not a good investment, then don't use your qualified funds to quote-unquote save it or save your paycheck. It shouldn't be invested. Just let the company go. The proper reason to use a rollover business startup is because the investment into this business, into this corporation or existing corporation, represents a reasonable expectation of a positive return to the plan, to the employee whose funds are inside the plan. In my opinion, that is the only reason that funds ought to be invested from the plan into the company. The only reason somebody ought to go through a rollover business startup is based on the fact that their plans, their expectation of return through the plan. So, of course, sometimes people will have an opinion also that this is a better financing for their company than getting a loan, for example. And that certainly is legitimate to raise capital through investment like this rather than, or maybe in addition to getting, for example, a small business loan. And that I'm not discounting that as a reason people go through a rollover business startup. But again, from the focus of the investment from the plan into the company, at that point in time, there needs to be an expectation of a reasonable expectation of return to the employee whose funds are being used to invest in the company. And if that doesn't exist, then people should not be using this concept. Go ahead. So top mistakes I've seen people make. So they have a legitimate expectation of return. Their business looks sound. They're going to invest in qualified funds. They get the whole process rolling. They've got a promoter like Active Plan on board. It's going to walk them through all the process. The product is sound, and yet there are some things that people can do along the way to mess themselves up. So one of the things that I've seen that people do incorrectly is they will request a transfer properly from the existing custodian and ask that those funds be transferred to the 401k account. However, instead of depositing those funds into the 401k account, they invest, put the money directly into the corporation. And that is not the proper completion of a plan-to-plan transfer or direct rollover. To be properly construed as a direct rollover or transfer, those funds have to be received by the plan. So make sure that those funds go into the plan account and nowhere else. Second mistake I've seen people make is that they will spend funds that are inside the 401k plan have been properly transferred into the plan, but then they'll start writing checks off of the 401k plan account to pay for business expenses. That is flat out illegal. When the funds are inside the 401k or under the control of the 401k, the only thing that you can do with that money is invest it according to the plan's investment policy. You do not use 401k plan funds to pay for company bills. Of course, those funds can be invested in the company, and then the company pays for its bills. But we don't pay for company bills when the funds are sitting in the 401k account. The third mistake I've made, or I've seen people make, is that they will invest funds properly from the plan into the company, but then issue the stock back to themselves rather than to the plan. So the plan needs to own the stock for the investment that's being made from the plan into the company, and it's holding that stock for the benefit of the employee, the individual whose money it is. If someone were to incorrectly issue the stock to themselves, they've essentially created a distribution from their plan, taxable event, if not prohibited transaction on top of that. So we definitely want to make sure that the plan ends up owning the stock. Finally, and this doesn't happen very often, but I have seen it a few times, where the stock is correctly issued to the plan. However, the individual treats that stock as if they owned it. They'll treat the corporation as if they were the sole shareholder, that they owned 100% of the stock. And they'll do something like make an F election and claim that they owned 100% of the stock. And that's not right either, even if the stock ledger were to correctly identify that plan as a shareholder, to then treat it later on as if you owned it all would be incorrect. So we want to make sure that we're accurately representing the corporation as a two-shareholder corporation with a plan owning its percentage of the business. Go ahead. And that would, sometimes comes into play also with a business loan application, small business loan process, etc. Now, on my website at frankseldenlaw.com, Selden is spelled S-E-L-D-E-N, so go to frankseldenlaw.com. There is a tab, R.O.B.S, Rollover Business Startups, and in that tab is a lot of information about how to correctly put together a rollover business startup. So feel free to see that for more information. Go ahead. There's also a contact tab there if you want to email me directly. You can go through the contact info on the website or just email me, Frank at frankseldenlaw.com, or call the office at 425-990-1021. Go ahead. And that's what we have for the prepared comments portion of this webinar. And I believe that we have several questions to go through. Lamarr, you want to get started on those?
Okay, what we're going to do is, in addition to, we're going to get to the Q&A session. I'm going to go over some additional information that I think the listeners should be aware of, and in particular, we covered areas relative to top mistakes. So, as Frank mentioned, it's important that you follow the proper steps and procedures. And if you're not sure, you should definitely be consulting with someone like Frank, and as well as a knowledgeable CPA or a tax professional who specialize in this area of an investment structure. So what I want to do is cover some of the areas about the self-directed IRA or the self-directed 401k. As he mentioned also, not every custodian will set up the self-directed 401k to allow you to do this structure. So it's very important before you move forward in terms of establishing a relationship with the custodian that you contact the proper custodian that basically can aid you in the structure of this type of plan. AccuPlan is a national company. We offer both the self-directed IRA as well as the 401k. So once again, our staff special, this is a niche product or niche area for us. So if you're looking for a proper setup in terms of the R.O.B.S plan, getting everything set up and us setting up the plan agreement and whatnot, we do offer that service. So for more information, definitely go ahead and give us a call. What I'd like to cover is prohibited transactions because, as he mentioned in terms of top mistakes, it's really important that you understand the rules of prohibited transactions. They do still apply as it relates to making sure that the funds are properly transferred over to the corporation in exchange for stock. So you want to make sure that you understand that, for example, an IRA, in this case a 401k, cannot engage in any transaction, direct or indirect, with anybody or anything considered related to the IRA 401k. Just kind of give you some examples of prohibited transactions would be any transaction between a disqualified person, which we'll cover in an upcoming slide, who a disqualified person or party would be with an IRA or 401k. Some examples would be the selling or exchanging or leasing a property, lending money or extending credit, furnishing goods and services and facilities. Two key points with an IRA or 401k in self-dealing is no self-dealing and no personal use. So it's really important that your accounting is in order with the R.O.B.S plan. Frank mentioned in terms of paying business expenses with 401k funds. As he mentioned, it's important that you transfer or roll over those funds from the 401k into the C-Corp that's owned by the 401k, and then the C-Corp or the business will actually pay the expenses. I know a lot of customers make that mistake when it comes to setting up an LLC. The same mistake is that they'll pay expenses for the LLC directly out of the IRA or 401k. The entity in which is owned by the IRA or 401, in this case the 401k, has to be the source that's paying the expenses. So that's something that's really important, and I think everyone should take note of before moving forward and making sure that they understand that there should be accurate and proper bookkeeping principles in place when using this type of plan or structure. So an example of a disqualified person, and these are parties who cannot, for example, engage in terms of personal use or benefit from the use of the 401k or IRA funds, be you, your spouse, any lineal ascendants and their spouses, any lineal descendants and their spouses, any fiduciary of the IRA or 401k, anyone providing services to the IRA 401k, corporations, partnerships, trusts, so on and so forth, whereas the account holder has a majority stake in the actual organization. So for more information, you definitely, before moving forward, is to give me a call. I'd be happy to answer any questions. But in the very end is basically we want to make sure we have that conference call with whoever you're going to be consulting with as far as your legal or tax professional before moving forward. Because as we mentioned earlier in the presentation, this structure as well as the actual plan is not for everyone. If this is not something that you can grasp or have a team in place to help you along the way, it could get you into a lot of trouble, not to mention disqualification of your plan and taxation and penalties as well. So basically you want to make sure you want to steer clear of any problems that will put you in harm's way with the IRS. Here's a structure in terms of what the process would look like in terms of opening the account, in this case funding the account, and then also funding the actual R.O.B.S plan. So first you want to go ahead and establish your account. This can be done online, or we can send you over a PDF application for you to complete the online application or the application via PDF. Then you're going to fund the account. So you have, in this case here, we're talking about a 401k, so you're going to be contacting your plan administrator or custodian and having them roll over the funds. As Frank mentioned, They will not basically listen to any third party, so it's important that you as the account holder contact them to initiate the process in terms of rolling over the funds. As like a transfer, they do not honor, unlike a transfer, they do not honor third party requests, whether it be written or verbal. So usually you have to contact them, provide them with certain information on the plan as to where you want the funds rolled over, and usually within 7 to 10 business days, those funds will be rolled over to that plan. So once those funds are rolled over to the plan, it's just a matter of basically moving forward with some internal documents with us, and we would then direct those funds over or forward those funds over to the C-Corp, and then at that point, in exchange for forwarding those funds to the C-Corp, you will receive that, meaning the IRA or 401k in this case will receive private stock in exchange for funding from the 401k. So this is pretty much the structure of what it will look like to establish, fund your account, and also fund your corporation through the R.O.B.S plan structure. So what we're going to go ahead and do at this point is go ahead and get into the Q&A session. Before we move forward, I'm just going to kind of cover a summary of what we just covered today. A R.O.B.S plan is not illegal, despite what you may hear from both legal and tax professionals. As Frank mentioned, if properly structured with several aspects of putting certain pieces together to make this work, this is a viable plan, as we mentioned, not for everyone. You definitely want to do your due diligence and make sure that it's properly structured. A R.O.B.S plan can be used only for existing and startup businesses. No self-dealing is allowed, so you make sure you want to make sure that you're aware of the prohibited transaction rules and disqualified person rules before moving forward, and making sure that based on how you're looking to operate that business, whether startup or an existing business, that you are aware of all the IRS rules. The R.O.B.S plan must be a setup using a 401k and a C-Corp entity only, so you cannot use any other retirement plan, and you cannot use any other form of an entity such as an LLC or an S-Corp. It has to be a 401k as well as a C-Corp structure in order for this to be a permissible and legal plan. The plan can be set up only by a select few custodians. As I mentioned, this is something that we do offer in-house, so we're going to make sure that you do receive a proper plan and a compliant plan that's being set up. So you definitely want to do your due diligence on any custodian that you're going to be considering to set up this plan for you to make sure it's set up properly. So with that being said, we're going to go to the Q&A session of the presentation. And the first question is for Frank. How long has the IRS allowed this structure?
I don't know that I would phrase it as the IRS allowing. The IRS typically, they're an enforcement, but along that same line, they haven't exactly shut it down either. The Internal Revenue Code allows this exemption, a qualified employer exemption, has been there in the 401k plan legislation from the very beginning. It was not construed as something that could be used to start a new business from the very beginning. That actually was something that came along later due to some creative thinking by an ERISA attorney with the last name of Cooper. But he essentially is credited with putting the first type of rollover business startup structure together. And that happened over 30 years ago. So this has been around for quite a while. It's gained a lot of popularity in the last 5 or 6 years. People are looking for alternative funding sources for their companies as some of the financial markets have dried up a little bit on making loans available. So, due to a lot of different economic factors and not having really great returns in the market for their qualified plans, within the last 5 or 6 years, this concept has gained a lot of popularity. But it's actually been around for quite a while.
And that's a good point. Here in Northern California, in particular Silicon Valley, there's a lot of the tech companies and the tech professionals who've been laid off, and of course a lot of them have pretty large 401ks and very experienced in their profession. So a lot of times when they're looking to start an organization or start their own business on their own, they're usually running into roadblocks in terms of obtaining capital or financing to start the business. So this is definitely an area that's gained popularity over the last 5 years as it relates to using 401k funds to start a business. So this is something definitely that's beginning to pick up steam, and I think we'll continue to move forward and gain more popularity as this economy somewhat remains stagnant and the banks have real stringent and strict lending guidelines for especially startups as well as existing businesses as well. The next question is, why is the 401k the only retirement plan type that can be used for this investment structure?
Well, for a full and complete answer to that question, you really have to ask Congress. Mm-hmm. Why did they write the rules this way? I mean, the bottom line is it is the only qualified fund, a type of product, whether you're looking at 401ks versus IRAs, et cetera, 403Bs, several different types of qualified plans. This is basically the only kind of plan, the only exemption to the prohibited transaction rules that's allowed. Why? Don't know. That's a congressional thing. But the good news is at least it's allowed in this, so it's what we make use of.
Okay. Next question is also for you. Does it matter that you are not a California attorney and as it relates to seeking consultation on establishing a R.O.B.S plan?
No, it doesn't matter because the advice that I give people is federal in nature and I can practice it all over the country. I am licensed to practice law in Washington State. I do offer some estate planning and business planning legal advice, but only to Washington State clients. But the rollover business startup rules are federal in nature, and I can discuss those with people all over the country. And I do make it very clear with our clients from states other than Washington, and actually most of my clients are from states other than Washington, and I'm very happy to help them with the federal rules. But I don't provide legal advice on the state issues.
Yeah, so that's a good point. So for those who are on the call, the listeners, you should basically consider when also considering consulting with Frank. As he mentioned, he definitely can help you with the federal rules, but at some point you definitely will need to consult with an attorney within the state you're going to be operating in and make sure that that person giving you advice is abreast of those rules relative to that state. And I know that comes up also in the LLC structure in terms of getting advice on that as well. So the same rules would apply for the R.O.B.S plan in terms of getting legal consultation. As he mentioned, this area that he's covering is based on federal law, not state law. The next question is, in your personal opinion, why do you think attorneys and CPAs are anti-R.O.B.S structure? Is it a combination of maybe just against it personally or just lack of knowledge in the area?
A couple of different reasons. One, I was chatting with an attorney one time that is just flat out against rollover business startups, and found out that he actually owned a company that put self-directed IRAs together, but he didn't own one that put four R.O.B.S together. And he was basically shying people away from rollover business startups and pushing them into his company that would do self-directed IRAs. So I thought that was a bit of a disingenuous reason. The only reason that I've come across that I think is a legitimate concern from CPAs and attorneys has to do with the prudent investor standard for 401k plans. They take a look at the business that their client wants to invest into and say it just doesn't work with a prudent investor standard. You're not making a legitimate investment here from the plan into the company or in refinancing an existing business where it really, no matter how much money you throw at it, it's not going to work. And that to me is a legitimate reason. And for the attorneys and CPAs that express that, I have no issue with that. If it does not meet a reasonable prudent investor standard, I don't want the client to do it either. They need to have a positive expectation that at the time of the investment from the plan into the company, that their business is a viable business and represents that expected positive return. So that's a legitimate reason. We've had some people that are skeptical because there is no one single rule that allows rollover business startups. They say, well, if you can't point to me in the Internal Revenue Code where this is allowed, then then I'm not going to support this. And again, there's no rule that allows this. And instead, there is an exemption to the prohibited transaction rules where an employee from a company can invest their dollars as an employee of that company into the corporate stock. But there's nothing about that being applied to a rollover business startup or a brand new startup corporation. So some of them are skeptical for that reason. I understand it. I'm not skeptical for that reason. This has been around for quite a while. Works completely fine. Had several clients go through IRS audits that come out through fine, and it works for people that put this together properly.
What would be your recommendation if someone was considering to move forward with this plan, and just for their peace of mind that they felt that kind of like any other structure where it's not really clear in the Internal Revenue Code as to whether it's permissible or not? What are your opinions as relates to someone considering applying for a private letter ruling?
I've had people ask whether they should apply for a private letter ruling. Those can be expensive and take a lot of time. If somebody wants to, I think that's fine. I think there's enough PRLs out there already that have been published that you can't rely on them as precedent. I mean, you can't say, well, my tax are the exact same as the ones presented there, and therefore this PRL applies to me. It doesn't apply to you unless you're the one that paid for it with the IRS. So you can look at them, though, and they can be educational. And I think when you take a look at the scope of all of those, there's enough material that the IRS has released its public information where they have expressed some concerns about rollover business startups. However, especially in a couple of memos, one in 2008 and one in 2010, they've also specifically said that this is legal. So it's I don't think a PRL would add anything, and I think it would be a waste of money and time to apply for one.
Okay.
Now, that's different than a determination letter for the 401k plan. I actually don't know how AccuPlan files the 401k plan. Some of the promoters use a prototype approach, so they don't have an actual determination letter for the specific client-created plan. It's instead based on a prototype, and the prototype's received a determination letter. You know, and some people say, I've got this prototype determination letter. Should I apply for a specific, you know, individual determination letter from the IRS? So that's a different concept than a private letter ruling on the whole scenario. And in some cases, just for client peace of mind, I've actually said go ahead and do that. Although if the plan doesn't deviate from the prototype, it's not necessary, adds an expense and adds extra time as well. So, but if they've made some changes to it, that might be something they want to consider.
Sounds good. Okay. Next question would be, what are the, in your mind, some of the more common mistakes for misuse of a R.O.B.S plan or the 401k in conjunction with the R.O.B.S plan that resulted in the disqualification of the 401k? Anything that you can think of at the top of your head that resulted in a disqualification for them violating prohibited transaction rules using a R.O.B.S?
If they're essentially running the business out of the 401k plan and got caught doing that, I think the whole thing would be disqualified, and it would all be considered distributed to them and taxable. And if they're under 59.5, an additional 10% penalty and a prohibited transaction penalty, no matter what age they are. So that, to me, would be the most egregious thing that somebody could do, would be to essentially run the business out of the 401k plan.
Got it. Okay. Now, I noticed you mentioned that you had some links on your website. So I noticed a lot of those links look like it pointed to specific areas in terms of memorandums on the IRS website. So in addition to that, is there any particular areas on the website that would discuss anything relative to the R.O.B.S on the IRS website?
Everything that I can find that I can link to is on that page. I'm also very happy to, you know, if somebody says, hey, I found this and it looks very relevant, you know, you might want to consider linking this. I'm always happy to do that.
Right.
But so far, you know, from my own poking around and investigating things over the years, those are the pieces I found helpful. I also know that the IRS, for some reason, is notorious for changing the links on their website. Mm-hmm. They'll change a letter or something in a folder, and then everything under that folder, the link doesn't work. So if somebody finds a link that isn't working and they still want access to that, the probability is that what they're looking for is still on the IRS website. It's just in a slightly different path, and we have to go back and re-find it. And I'm always happy to have queries from people of, hey, I was poking around on your website, and this link doesn't seem to be working to the IRS website, so can you find that information for me, what you're talking about? Happy to do that and refresh any links that end up being broken.
Okay, sounds good. The next question here is, can a R.O.B.S plan be used for to fund an existing business? I know in most cases it's always talked about for funding a startup business. So what is the rules? Any special rules for funding an existing business?
Yes, very good question. There are a couple of extra steps that I would recommend. Usually for a brand new startup company, the board of directors is deciding on some type of stock price to get the whole thing going. So how do you calculate this? If the client's investing $100,000, how do you calculate how many shares to issue back to the client? On a brand new startup, that's usually a function of the board of directors. However, on an existing business, there is an actual stock price at the time of the transaction, and that stock price needs to be determined. And then the plan buys in at that price. So there's an extra step for funding an existing business of doing the stock price determination or valuation.
Okay. Are there any time limits on the structure of the 401k used to fund the C-Corp? So in other words, do they have any particular time that they have to pull those funds out of the C-Corp for funding that R.O.B.S plan structure?
Pull the funds out of the C-Corp. It's normally the funds are going from the plan to the C-Corp, not the other way around. So one of the questions I get sometimes from people is, at what point in time do I have to have the operating company established? Because the requirement in a rollover business startup is that the C corporation be an operating company. Well, unfortunately, the rules don't give us any length of time to create an operating company, and this is where the outside the box and sometimes the hesitation, I think, of some CPAs and attorneys comes into play, because the exemption to the prohibited transaction rules for qualified employer securities expects that the corporation is an operating company at the time of the investment. And there is nothing in the rules that allow you to create an operating company down the road from the money that's put into the C corporation now. The expectation is that's already in place. However, for a true rollover business startup where you are starting a new business, we don't have a single client who has ever had an operating company. You know, the corporation isn't an operating company. It needs the capital from the plan to become one. So we've not seen the IRS disqualify or make an issue out of the fact that the operating company isn't in existence, but all of our clients also have business plans or franchises or deals in the works, so they can say, this is what I'm doing with the money, and create the operating company shortly thereafter. So it's not been an issue that's ever been addressed. My concern is that if you just make an investment from the plan into a corporation and leave it there and don't create a company, you haven't met all of the requirements of the qualified employer securities exemption. So then the question comes into play, well, how much time do we have? Don't know. You don't actually have any time. It's supposed to be there. So we've had some clients whose business deals have gone south on them. The seller pulled the plug, or they found some things that were not right about the business that they were buying. We actually had one client that discovered a second set of books when they were going through the materials, and showed that the company was not in the good financial situation as it had been portrayed to them. And that deal, they of course didn't follow through on buying that business. So here they are with funds inside a corporate account and no operating company. And it stayed that way for probably about 6 months before they found another business they were comfortable buying. So there can be a time lag. Is the time lag allowed by the rules? No, there's no time lag specified. So, my recommendation is have that set before you make the investment from the plan into the company. Get as far along in that process as possible before you pull the trigger on the investment from the plan into the company.
Got it. Okay. Next question here is, what are some of the more common or popular business types or industries that have benefited from the R.O.B.S plan? I know I have a relationship with franchise brokers. Any that you can think of, any industries that you've seen that done very well using this structure?
As an industry, I don't think that the industries do any better because people are using their own retirement funds. So, if somebody's going to start a restaurant and you're starting it using this method, I think you have about the same chance of success as anybody else who starts a restaurant. So it really is incumbent on the client to do their due diligence and make sure that the business that they are conceiving is a viable chance of success. Now, you mentioned franchises, and that's interesting because the rollover business startups have just helped the franchise industry in general tremendously. There are a lot of franchisors that are now using rollover business startups in consultation with their potential franchisees as ways of financing their franchises, franchise purchases. So it's definitely popular in the franchise community in general, but I haven't really been keeping track of specific businesses, whether restaurants or a golf club or a hotel or whatever, different businesses, to whether some of them are more successful than others, just because they're using a rollover business startup.
Got it. And actually, this next question also will tie into what we just discussed a second ago here. Can you combine multiple 401ks from multiple investors to fund a business using this structure?
Not exactly. You can't combine multiple 401ks. What you can do is every employee of the corporation has a right to transfer their qualified funds into the plan that is sponsored by the corporation, the sponsor and employer. So if they are an employee of the company and you have several employees, people coming together who all are going to work for the company and want to pool their qualified funds into the corporation, yes, it's possible, but we're using one plan, specifically the plan that is sponsored by the corporation, the sponsor and employer. So they can bring their funds into that plan and all use qualified funds. So they can also use personal funds. There's no restrictions. If somebody wants to put personal funds in, they don't have to be an employee of the company. The people behind the corporation can open up their company to whoever they want to. But if they're going to use qualified funds, the people investing in the qualified funds have to first be an employee of the company in order to have a right to transfer qualified funds into that company's plan.
And so in essence, what would happen is if it was 3 investors, they would all become employees of that corporation, use their individual 401ks to roll it over into that one plan to be able to invest.
Yes, exactly.
Got it. Okay. Okay, and the last question here, how long, and I guess this will be more or less my question here, how long does it take to set up a R.O.B.S plan? Usually it's anywhere from 4 to 6 weeks, but it's really going to vary from state to state. I know here in California, it's setting up any entity. I know in terms of setting up the LLCs, it's now taking anywhere from 4 to 6 weeks just to get it filed with the Secretary of State. So I'm going to pretty much say it's going to take, opposed to 4 to 6 weeks, I'm going to say 6 to 8 weeks for states such as California, just based on how long it's taking them to basically do all the filing in this particular state. But it could be shorter depending on the turn time or the filing times in the individual state to where you're going to be setting up the C-Corp. And then the next question, it looks like, also be directed to me. What are the setup and ongoing costs for this type of structure? It really depends. So I would say the range would be anywhere from $3,500 to $5,000, depending on what's needed. You definitely want to give me a call, and I'd be happy to convey that information to give you an idea of what the cost structure would be. But we pretty much take care of everything in terms of actually setting up the 401k. The price that we would charge will consist of setting up their actual R.O.B.S plan as well as the fees for the setup of the 401k as well. So if you have any questions on that, feel free to give me a call. Let's see. One other question here is, and I think we already answered it. Can you combine the 401ks for more than one investor? So it looks like we've pretty much covered all the questions that I have here in front of me that had come in during this session. Anything else you want to add to this, Frank?
No, I think it's actually been a very good call. We've covered all the basics and walked through some other questions. So if people do have any questions of a legal nature that they want to run my way, feel free to look at the website, frankseldenlaw.com. All my contact info is there. And if it's more of an administrative question, then how does this get put together and what is AccuPlan's plan? consist of, et cetera. Those kinds of questions definitely best directed at Lamarr. And
Okay.
happy to chat with anyone who has any curiosity about rollover business startups.
And just an FYI, we AccuPlan and myself particularly actually have referred several clients over to Frank, for consultation. So as we mentioned earlier, not everyone is specializes in this area. So definitely, if you want to be working with someone that's knowledgeable and knows their stuff when it comes to properly structuring or setting up this type of plan, you definitely want to go give Frank a call for that consultation. And like I say, if you're ready to move forward after you speak with Frank, feel free to give us a call. And any questions prior to setting up your plan, I'd be happy to answer any questions on my end as well. So with that being said, I'm going to go ahead and wrap this up for today. I'd like to thank everyone for attending today's webinar. And as I mentioned earlier, this webinar has been recorded, and within the next 24 to 48 hours, I'll be forwarding out a playback link via email for you to listen at your leisure, as well as to forward along to others who may have not been able to log on to today's webinar but was interested in today's topic. So I'd like to thank everyone and thank Frank especially for sharing some very powerful and valuable information on this plan and structure. Thank you and have a great day.
Thanks, Lamarr. You too. Appreciate it.
All right, goodbye.